You can take it off the screen. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. Today we have what is called an arraignment. The arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. You have a criminal case in this court. Criminal cases are divided into felonies and misdemeanors. You have a misdemeanor case. The difference between the felonies and the misdemeanors are as follows. The misdemeanor case are your most serious type of criminal cases, whereas your felony cases are your most serious type of cases, whereas your misdemeanors are referred to as petty offenses. Does not mean that they are not serious. It just means that they are not as serious as a felony. If you had a felony conviction, you have a higher range of punishment than you have for a misdemeanor conviction. Felonies are divided into 5 categories. And I'll start at the top. You have a capital murder. Then you go down to a first degree felony, down to a second degree felony, down to a third degree felony. And then the lowest felony that we have here in Texas is a state jail felony. If you are convicted of a state jail felony, the range of punishment is minimum 6 months to 2 years in the state jail and a fine up to $10,000. If you're convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second degree felony, the range of punishment, minimum 2 years to a maximum of 20 years and a fine up to $10,000. If you're convicted of a first degree felony, the range of punishment is minimum 5 years to maximum 99 years to life in the state penitentiary and a fine up to $10,000. If you're convicted of a capital murder, the range of punishment is life in the state penitentiary or death. For the misdemeanor cases, the misdemeanors are divided into 3 categories. The highest misdemeanor we have is a Class A misdemeanor, and then we go down to a Class B misdemeanor, and then the lowest misdemeanor we have is a Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is fine only. Now, for Class C misdemeanors, those are the cases that normally originate or start in either the city court, which is the municipal court, or the JP court, which is justice court. Now, as I said earlier, a Class C misdemeanor conviction results in a fine only. You cannot be given any jail time. Then the next highest misdemeanor is a Class B misdemeanor. The range of punishment is 0 days to 180 days in the county jail, a fine of $0 to $2,000. You could be given both such fine and confinement. Now, the highest misdemeanor we have is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is, if you're convicted, is a minimum of 0 days to a maximum of 365 days, which is a year in the county jail, and or a fine from $0 to $4,000. And I said earlier, you could be given both such fine and confinement. Now, as I said it earlier, the case that you have here is a misdemeanor case. So your case is going to fall into one of the categories of misdemeanor. Yes, explained. Next, we have now, as a defendant in a criminal case.
Mr. Terrence.
Yes. As a Miss Courtney, would you please keep your mic on mute? Okay. As a defendant in a criminal case, we have you have rights. And One of the rights that you have is a right to have an attorney. Now, the paperwork that you have in your hand, I'll go over that paperwork with you. And it explains, the first document explains to you your rights to have an attorney. Now, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. Now, the prosecutor is the assistant district attorney, works for the DA's office. Now, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. And the waiver is on the second page, and basically you'll be waiving your right to have an attorney and you'll be representing yourself. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including the loss of significant legal rights and opportunities relating to military service, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind and may request an attorney be appointed to represent you. Now, at the bottom of that document, it states, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If your choice is, well, if you have already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you've already been appointed a court-appointed attorney in this case, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will place your signature on the line that's titled defendant, and you will date it today's date, August 23rd of 2022. Now, for those of you who will be waiving your right to an attorney and representing yourself, you would have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 23rd day of August of 2022 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that is your choice, then you will sign on the line that is titled defendant, and you will date it today's date, August 23rd of 2022. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. For those young people are sitting in that area, we call that the jury box. Now, 6 citizens from Jefferson County will be selected to sit on your case as the jury, and they will decide after listening to all the evidence in your case whether or not you are guilty or innocent. You also have a right to waive your right to a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, your case you would not, first of all, you would not be having a trial by jury. And then next, your case will come before the judge in one of three ways. One way it could come before the judge is by way of a trial. We call that a bench trial. It's a trial by judge only. The judge will listen to the evidence and decide whether or not you're guilty or innocent after listening to all or the judge will decide whether or not you're guilty or not guilty after listening to all of the evidence. Now, the other way that your case can come before the judge is by way of an agreed plea bargain. Now, what a plea bargain is, it's an agreement between you and the state to settle your case. We call that a plea bargain agreement. Now, if you reach a plea bargain agreement before with the state, then your case will come before the court or the judge, and the judge will decide whether to follow, which means to go along with the plea bargain, or not follow, which means not to go along with the plea bargain. If the judge follows the plea bargain agreement and you decide within 30 days that you would like to appeal your case, what an appeal is, you would like to have a higher court than this court to look at your case to see whether or not this court has committed an error or whether or not you have been wrongfully convicted. And if you decide to appeal your case, then the court has to give you permission to appeal. The judge has to give you permission to appeal if the judge goes along with the plea bargain. Now, if the judge does not go along with your plea bargain case or with your plea bargain that you have reached with the state, then you will be entitled to, or you'll have a right to withdraw, which means to take back your plea. In essence, for example, let's say you and the state has reached a plea bargain agreement that you're going to serve, you're going to be on probation. And the judge says, well, I'm not going to follow that plea bargain agreement. Then you say, well, judge, I'll take back my plea. In essence, I don't want to plead guilty or to this charge or no contest to this charge because you're not following the plea. So I'll withdraw or I'll take back my plea. So you have a right to do that if the judge does not follow the plea bargain agreement that you have reached with the state in your case. Now, that's one way the case would come before the judge. The other way the case would come before the judge is by way of an unagreed plea bargain. What an unagreed plea bargain is that you and the state have talked about your case to see if y'all can reach a settlement. However, y'all have been unable to come to an agreement on the case, and you still want to enter a plea of guilty and no contest, but you want the judge to decide what the punishment would be in your case. We call that an unagreed plea bargain, okay? So just to recap, you have a right to have a trial by jury, one, and if you waive that right to have a trial by jury, your case can come before the judge or the court in one of three ways: by way of a bench trial, that's a trial by judge only; by way of an agreed plea bargain, that's agreement to settle your case; or by way of an unagreed plea bargain, which means you have not reached a plea bargain agreement and you want the judge to settle the case, to do or to set your punishment. Now, you also have a right to have, besides the right to have a trial by jury, you also have a right to have witnesses to come to court. You have a right to call witnesses in your case. Now, that area over there where that chair is, we call that the witness stand. And what witnesses do? They come and testify. They can testify for you or they can testify against you. Now, if you call witnesses on your behalf, you have a right to do that. Now, you also have a right to waive your right to call witnesses, which means to give up your right to call witnesses. And by doing so, you will not be calling witnesses. Now, just because you are not calling witnesses in your case does not mean that the state of Texas or the district attorney's office will not be calling witnesses. They will be calling witnesses in the case. Now, you also have a right to waive, as I said, waive or give up your right to have witnesses in your case. The other thing is you have a right against self-incrimination. Your Fifth Amendment right against self-incrimination. What that means is that you have a right not to testify in your case. State of Texas, the district attorney's office cannot force you to testify in your case if you do not desire to testify and if you invoke your Fifth Amendment right against self-incrimination. Now, you can waive which means you can waive your Fifth Amendment right against self-incrimination or give up your right against self-incrimination, which means that you can give up your right against your Fifth Amendment right against self-incrimination and testify if you desire to do so. Now, you also have a right to have discovery. Discovery just means you have a right to see the evidence that the state has against you. So if the state has any documents, any videos, audio recordings, any instruments or witness statements or anything in your case, you have a right to see the evidence that the state has against you. Now, you also have a right to waive or give up your right against self-incrimination, which, I mean, now you have a right to waive your right to have discovery. And what that means is you have a right not to see the evidence or have access to the evidence in your case if you do not want to have access to the case. So you'll be waiving your right to discovery. Now, everyone here today, you have been arrested on your case, and you're here because you're out on bond. You're here because you're on one of three types of bond. For example, if you were released and you pay cash of your bond, that you're out on a cash bond. Or if you have a bondsman, then you're out on a surety bond. Or if you did not have to put any money up to get out of jail or anything, you don't have a bond, you didn't put up cash, you were released on your own personal recognizance, then you're out on a PR bond. Now, every day that you spent in jail can be used as credit toward your case if you enter a plea guilty or no contest. Now, for example, let's say the state is offering you to settle your case. Let's say you spent 5 days in jail, for example. And let's say the state is offering you 5 days to serve in jail on your case. What that means is you will not have to serve any more time in jail because the 5 days that you spent in jail will be credited toward your sentence. So you'll be given what is called credit for time served, time that you already served. Now, if they're offering 7 days and you did 5, that means you have to do 2 days. Now, every day that you spent in jail also goes toward fine and court costs. So every day that you spend in jail, you get $100 toward your fine and court costs. So if the state is offering you to settle this case for fine and court costs of $500, you spent 5 days in jail, that means you won't have to pay anything because the time that you spent in jail has already paid it off. Therefore, you'll be given, your sentence will be, your fine and court costs will be taxed and retired. Now, if they say the fine and court costs of $700 and you spent 5 days in jail, that means you have to pay $200. And if you can't pay the $200 on the day that you're disposing of your case, then we can allow you to pay it off in installments. In essence, we could put you on what is called a payment plan, and you could pay it off in small monthly installments, the remaining balance. Now, if you cannot pay it off, the remaining balance, because you do not have the income, then the court can convert your fine and court costs to community service. And every hour that you participate in community service, $12.50 will go towards your fine and court costs. So, for example, if you work 8 hours of community service in one day, that means that it'd be $100 that will go towards your fine and court costs. Now, the other thing is Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. And with the pretrial diversion program, if you have not been in trouble, if you get into the program, the case will be dismissed, your case will be dismissed, and if you complete the program, then they can expunge, it will be expunged from your record. What an expunge means is erased, deleted, or wiped off from your criminal history. Now, in order to get into the program, it has to be your first offense. It cannot be an offense involving unlawful carrying a weapon or resisting arrest. And you have to get an attorney to assist you at doing the paperwork to get into the program. And again, if you get into the program, the case is dismissed, you complete the program, you can get it wiped off your record. It'll be expunged, so wiped off, deleted, or erased from your record. And if you're interested in that program, just let us know. We have paperwork here that we can, you may be able to sign here, or you can be directed to the place that you need to go to get that done. Okay, now the next thing we have is, okay, if you are a veteran of one of the branches of the military, there's a program that is called Veterans Court. And with Veterans Court is for veterans only. You get into the program, it's just like pretrial diversion. They dismiss the case, you complete the program, they erase it from your record, okay? So if you're interested in pretrial diversion or Veterans Court, just let the court know, and we have paperwork that you can fill out to get into the program. Now, this court has a program that is called the Community Safety Initiative. It's a program that I started in March of 2017, over 5 years ago. And that program is designed to address the issue of what we call recidivism. Recidivism just simply means that people commit crimes over and over. We call that recidivism. And so to stop that, or to prevent it, or to reduce it, I have a program that is called the Community Safety Initiative, short, and we refer to it as the CSI program. The CSI program is designed where we have partnerships with various agencies in our community. For example, we have a partnership with Spindletop. People that's sitting in the jury box, they're from Spindletop, and they'll come to you a little later and tell you about the program. But with the Spindletop program, Spindletop provide mental health services. And in this program, individuals who you don't have to be incompetent or insane to be in the program, because they can address anxiety, depression, schizophrenia, bipolar, PTSD, ADD, a whole host of mental issues that an individual may have. They can do a private interview. They can also do an assessment, and they can develop a treatment plan for either outpatient or inpatient treatment. They also have a program that is called ATAR. ATAR is a drug program. It's a program for drug and alcohol persons who are addicted or who have drug and alcohol or substance abuse issues. Also, Alcohol and Drug Abuse Council, which is a local council in this area, has a program that is called OZAR. Their program is similar to the ATAR program. And with that program, you're provided with a screening, an assessment, and then you could be referred for either outpatient or inpatient treatment to address your drug and alcohol issues. If you are unemployed, we have a program with the Golden Triangle Empowerment Center. We have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, then they will assist you at getting a job in the area that you're trained in. Also, if you have not graduated from high school, CICE also have a GED program that they can assist you to get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. These programs, as I stated earlier, is a program that we started. We started these programs back in 2017. And I tell people this: when you come to County Court at Law Number 2, Jefferson County, Texas, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference of the lives of the individuals that come before this court. And we're trying to make a difference in the community in which we live in by making Jefferson County a safer place for all of us to live, work, go to school, and raise our children. the program that we have here, I like to refer to it as, we don't just arrest the problem, we address the problem. We do not just give time, but we take our time so that we can address those issues that are plaguing people in our community to make our community better. And also, the program is designed to produce productive people. And we believe by producing productive people, then we can make our community better by it, because productive people have too much to lose. And so they will not commit crimes because now they have jobs and other things that they have that can benefit them. And so if you're interested in any one of these programs, just let us know. And then we'll be able to point you in the right direction so that you can get assistance to address whatever needs that you have. Now, at this time, we will have Deputy Hinton. He's with Spindletop. He's going to come before you and tell you something about the Spindletop program. Deputy Hinton. And we also have Chris, who is with him as well.
Thank you, Ron.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. This is my co-worker, Chris Whitmire. She is a qualified mental health professional with Spindletop. The reason that both of us are here today is because the judge has graciously invited us into this courtroom because he cares about every single person coming to the case. But the judge has found, more so than not, people who appear with legal issues commonly have mental health, substance use disorders, or sometimes just a lack of community connection to resources that would best fit your situation. Now, the judge believes that if he can help you with these underlying issues, which is why we're here to help you, he can get you out of the cycle of arrest. Now, maybe this is your first time to be here. Maybe it is your 10th time to be here if there's still hope. We actually have a system in place where we can connect you to the resources and help that you particularly need for your situation. We don't know what that is until we visit with you and find out. And I'm going to ask you to do something here in a little bit. I'm going to ask you to share that need with us so that we can help you. I know that may be a little uncomfortable, but that's the only way we're going to be able to help you is if you step out and ask for that help. Now, I'm going to have this flyer. I'm going to give this to you. And on the back of it tells you a little bit about what we do here in court. But on the front, there's a 1-800 number. Should you ever find yourself in an unsafe place, you can call the number and get help immediately. Now, Chris is going to explain the form that she's going to present to you and what we're going to do with that form and why it's important to fill it out and give that back to us before you leave your stage.
The important one that is also on that flyer is a 409 number. That is our office number. If you want to see the phone we call you, you're more than welcome to call that. If you don't hear us back to you, you change your mind. Again, you're more than welcome to call that. That 1-800 number as well is Texas Line. So even if you're not connected, it's still they'll get you connected to the most resources even here. I know something important to do. Now, one of the paths to help is a brief and graphic form and also functions as a different consent. What this does, it will, as a different consent form, all the information you provide on is covered by state law. It will not be shared outside of the commission. All this will allow you to do is contact you. Because as I said, it's a lot of times just research. There's a lot of stuff in the area that people aren't able to connect to. So don't know about it. The application process is difficult. Maybe they just don't have time and they're just trying to survive. Whenever we talk about mental health, it's anxiety, it's depression, it's the stress of life, which being in court doesn't make it easy. We've all showed up. So we can use this moment to put something productive in place. Why not? We also have the option to speak privately in the jury room if you like. And again, just like this, all the information shared is private. It's just for your benefit. If mental health isn't a concern, we also have other resources for physical health, for job training. There's resources available right now for mental assistance. It's just what you need and how can you help. So we're going to come around and have some events. I think everybody should already have things with clipboards over there. If you need it, you can have more. And we'll just come around if you want to speak privately, we'll let you know. If you have a specific resource, you can put it on here if you need. And as we put them up, I usually call on Wednesdays. If you have a time to work over, just put it on paper.
In a few minutes, the judge is going to go into recess and then we'll be busy. Thank you, Ron.
Oh, you're welcome. Okay, now, ladies and gentlemen, the paperwork that you have in your hand, if you need any assistance with that paperwork, we have our staff personnel will be happy to help you with any questions that you have to assist you at filling out that paperwork. Now, what we also, once you have finished with the paperwork, our staff is going to pick up the paperwork from you, and then we're going to go through the paperwork, and then we're going to call you up here one at a time. And then your case is going to be in one of three categories. Either you want your case reset to hire an attorney, or you want to see if you qualify for a court-appointed attorney, or you want to waive your right and represent yourself. And if you're waiving your right to represent yourself, obviously you have to read and sign that second page that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And for those of you who will be applying for a court-appointed attorney, you would have to fill out a financial affidavit. And on that affidavit, it has to be, it'll have information concerning your name, address, whether or not you're married, have any children, whether or not you get any government assistance or not. Also, it has a category as to what your housing situation is, and your monthly income. If you're working or not working, receiving any benefits, have any assets, all of that's to the bottom left of the form, and to the bottom right of the form, it has your expenses. And on your expenses, obviously, it will have if you have a rent, a house note, whether or not you have any utility bills, make sure you add those up. Also, if you're receiving or paying any child support, and now the transportation and food, there's a part for food. There's also a part for transportation. And when we talk about transportation, we're not only talking about your gas that you're paying in your car, but also your maintenance, also your car note and your insurance. So you add that up, that's what be your transportation cost. And so as you go down that form on expenses, when you get to the bottom on the expenses as well as your income, it says total, you just have to total everything up. And then on the next page, there's a part for your defender's signature. It also has your information. You're gonna do you have to fill out that information where it calls for your name, address, etc. And then I think that's all you have to do to fill the first two pages out. And then once we get the paperwork from you, then we'll go over it, and then we'll make the determination as to whether or not you qualify or do not qualify for a court-appointed attorney. So at this time, we will be in recess. As I stated earlier, if you need any assistance, just let us know. So at this time, we'll be in recess. And now, next, I have Miss Courtney Hutchins. Miss Hutchins, I have two things. Miss Hutchins, can you hear me? I think your mic is on mute.
Yes, sir. I'm so sorry. I'm here.
Okay, now, Ms. Hutchins, I have two things that I must do. The first thing is your case is going to be reset till November 4th, 2022.
November 4th, you said, I'm sorry?
Yes, November 4th, 2022 at 9 a.m.
Okay. And that is there, correct?
What did you say?
And that is there, correct, at the courthouse?
Yes, you need to be here in person, right?
Okay.
And your bondsman will be sent notice of your reset date, so stay in contact with your bondsman.
Yes, sir.
Okay, now the other thing is, the case that you have is a DWI, and we have the bond conditions that I'm going to read to you, and then these bond conditions also will be sent to your bondsman, okay, to give to you. Okay. So it reads, standard bond conditions in county court at law number 2, and this is cause number 332420. Standard bond conditions in county court at law number 2. Case is style of state of Texas versus Courtney Allen Hutchins. And it reads, following the arrest and accusation in county court at law number 2 of Jefferson County, all bail bonds for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Ms. Hutchins, do you understand that condition?
Yes, sir.
Okay, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who may refuse to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2.
Yes, Your Honor.
And condition number 3 in the bond does not apply. So we'll go to condition number 4. Now, your case is a DWI second, which falls under the section of 49.04 through 4906 of the Texas Penal Code. So section 4 of the standard bond conditions states, a defendant who has been arrested or accused of any subsequent offense listed under section 4904 through 4906, which is your case, of the Texas Penal Code, shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after today. Ms. Hutchins, do you understand that condition?
Absolutely. Yes, Your Honor. Thank you.
Okay, and so, Ms. Hutchins, once you get the interlock, you need to provide proof to the court. You'll have 10 days to do that. Someone would have to bring it up to the courthouse. If the court is not in session at that time, when you come, there are some doors next to the courtroom. You can go through those doors. There should be a receptionist sitting behind the window. And she will contact us and we'll come out and get proof of the intoxilizer from you. Do you understand?
Yes, sir. I actually already have it. I've had it since this happened. So I've had it since either October, November. Ben
Okay.
Collins, I got an occupational license from, so.
Okay, so you just need to have the proof brought up to the courthouse.
Okay.
All right. So, Ms. Hutchins, this will conclude your case. Again, your case is reset till November 4th of 2022 at 9 a.m. in County Court at Law No. 2 of Jefferson County, Texas. You're free to go and you have a blessed day.
You too. Thank you so much. Have a great day.
All right, thank you.